And to some other development, the Federal High Court in Abuja has held that challenges to a candidate's educational qualification are pre-election matters and cannot be raised as an election petition matter after the election. In a judgment delivered by Justice Muhammed Umar and obtained by New Central Television, the courts in a suit filed by the Nigerian Democratic Congress challenging provisions of the 2026 Electoral Act held that questions concerning the qualification or disqualification of a candidate must be addressed at a pre-election stage, particularly during the political party's primaries. Relying on an earlier decision of the Court of Appeal, Justice Umar also voided Section 77, subsection 5 of the Electoral Act 2026, ruling that the National Assembly, through an Act of Parliament, cannot impose restrictions on political parties that conflicts with powers guaranteed to them under the Constitution. Joining us in the studio to discuss this, a legal practitioner, Vincent Otwapopo. Many thanks for joining us. Vincent, first question.
Thank you for having me.
Thank you. You're welcome. What is the immediate implication of this ruling for candidates whose educational qualifications are being challenged after an election? And does it effectively close the door to such challenges through election petitions?
Okay, so you will recall that this law, Electoral Act 2026, was signed into law by the President, taken on 19th of February 2026. And we saw the need to challenge some aspect of the provisions of the Electoral Act, which you have referenced in your listing, especially Section 138, which have now drastically, have removed the issue of qualification from as a ground to challenge the return of a candidate for presidential election, for office of president, governor, House of Reps, Senate, and House of Assembly of a state. Contrary to the provisions of Section 66 of the Constitution, 66 of the Constitution for House of Reps and Senate, Section 107 of the Constitution for House of Assembly of a State, Section 137 of the Constitution for the office of the President, and 182 for office of the Governor of a state, which provides that for you to be qualified to contest for the election, you must possess some basic educational qualifications. But one who presented a forged certificate to INEC stand disqualified. So by the Constitution, there is still recognition of educational qualification as a ground to challenge election at the tribunal. But the Section 138 of the Electoral Act, which we went to court to seek the leave of the court for the court to strike down, seek to have removed that ground from the Electoral Act. What is there now is just two grounds: that the election is marred by corrupt practices and non-compliance with the provisions of the Electoral Act, and that the fellow elected did not match with the lawful majority of lawful vote cast. This is contrary to the provision of Section 22 of the Electoral Act 2022, which has not been repealed. So we approached the Federal High Court to have this section struck down, but the court said that Section 138 is complementary of those sections of the Constitution. Beyond this point, we also asked the court to strike down Section 77(5) of the Electoral Act, which have now provided that all political parties must submit lists of their membership register, digital register membership to INEC. And a fellow whose name is not there, a member whose fellow name is not there, is not eligible to contest, participate in the primary election of the political party. So to us, we look at that this is inconsistent with the clear provisions of the Constitution, especially Section 40 of the Constitution, which says every citizen of Nigeria have right to assembly and association and to belong to a political party of their choice. Then take it down. Section 65 deals on qualification to office of the House of Reps and Senate, 66 for House of Assembly, 131 for President, and 177 for office of the Governor of a state. And those qualifications provides that for you to be eligible for those elective offices, you must be a member of a political party and sponsored by the political party. Right. So there is no duration for membership. There's no time frame that you must be a member of a political party for you to be eligible to contest under those sections. So we now said that the Electoral Act Section 77(5), which have now introduced you to be a member of a political party, 21 days to the submission of list. Right. To the primary election, you must be a member. Your name must be contained in the list of register of members submitted to INEC 21 days to primary. Right. Which says that provision seek to introduce further qualification obligation or seek to limit the exercise of right created by these provisions of the Constitution, and by section, and it become inconsistent with the clear provision of the Constitution, and by section 1(3) of the Constitution, which provides that if any law is inconsistent with the provisions of the Constitution, that other law, to the extent of its inconsistency, be void. So that is what the court has said. So the court agreed with us and struck down the provision of section 77(5). And the implication is that political parties are no more required now to submit lists to INEC 21 days to primary election, and anybody whose name is not there will not be eligible to participate. That has been struck down.
All right.
Beyond this point.
Vincent, we will come back to you shortly, all right? We will come back to you to continue this, because we're also going to look at the impact of this in the 2027 elections. And going forward, how do you think that political parties should posture themselves to align with this new ruling by the Federal High Court? So we're back after this short break. Do stay with us. Welcome back. This is the 6th edition here on News Central. Of course, we still have with us Vincent Otopopo, just giving us an insight into the latest ruling. I mean, Vincent, you were saying something, and I just wanted to find out, this is just 5 months to Nigeria's presidential elections. We're talking about the presidential and the Senate, the House of Representatives elections. And of course, we have 6 months to the gubernatorial elections in February. How does this impact on candidates ahead of the elections?
It will not have much impact because the primary elections has been conducted, and all the political parties have also choose their candidate and submitted their names to INEC. And INEC have now officially published the names of those candidates in line with Section 29 of the Electoral Act. And after publication, other action and activities will flow. So it will not have much impact on the candidate, but for future elections, the law has been concretized. The law has been cemented by the judgment of the court. Already, there's already an existing judgment of the Court of Appeal on this, which the court have now further adopted in the Zenith Labour Party case that have also struck down that section 77(5). So while we are in agreement with this, the Federal High Court, because I filed the action for the NDC, you know, where we agree with this Federal High Court on the aspect of section 77(5), which for all intents and purposes is inconsistent, not only repugnant to natural justice, equity, and good conscience, but incompatible with the provisions of the Constitution. But we beg to disagree, with our face frowned, with the trial judge of the Federal High Court on the aspect of section 138, that have now removed educational qualification as a grant to challenge the election at the tribunal. There is no country in the world, where people who seek to govern the people, the masses, does not at least present satisfactory evidence of educational qualification. It does not add that you're going to do well or not do well as an elected officer. But people should have at least the minimum requirement of people who seek to govern them.
Do you think that particular ruling tends to shield certain candidates?
No, I will not say it tends to shield certain candidates, but it is obvious. It is obvious. Surprisingly, this amendment, the National Assembly have this amendment to remove. It has all been there. 2010 election, 2010 Electoral Act, 2022, all the previous Electoral Act will have this issue of qualification. You must scrutinize the paper submitted by a person who is seeking to govern. So now that people have to go to Ojueleba, go to any wholesale market, and they go and procure document, even in UTC here, and say, I have attended so university, primary school, secondary school. There should be a way you have to subject this into scrutiny.
Don't you think it might be discriminatory? I mean, if you are a Nigerian, you can vie for any position. I mean, no matter your educational qualification.
No, the provision of Constitution have said now, for section 66, 60, 106, 131 for president and 177 have said that you must have at least senior school certificate or its equivalent. So you must at least have. We're even calling for a further amendment of the Constitution. There should be satisfactory evidence of primary, secondary, university degree certificate must be attached by one who wants to govern how many million Nigerians, and with a condition that such certificate attached must be verified by the institution.
So are you appealing that particular
Of
ruling?
course, we are looking at the option, the available options, especially those aspects, the aspect that has to do with Section 138 on educational qualification. Because the Constitution has said, if you present a false certificate to INEC, you stand disqualified. The Constitution do not say that it should be a pre-election dispute or post-election dispute. So you cannot limit it as a pre-election dispute, as a complementary to the provisions of the Constitution. How does it complement the provision of the Constitution? The Constitution have said, if you present false certificate, among other listed the ground, a lunatic, one who have been ex-convict, you know those grounds there. Right. So there's no way I disagree that it is complementary to those provisions. So where the options to know whether we can challenge it on appeal or not.
Vincent Otabobo, many thanks. We truly appreciate your insights on the program this evening.